One of the most recognisable figures from the 2022 Freedom Convoy protests in Ottawa has been found guilty of 2 counts of mischief. Pat King walked into court earlier this morning facing a number of charges, including mischief, counselling others to commit mischief and obstructing police in connection with the protests that gripped downtown Ottawa. The Crown alleged King was instrumental in the disruptions caused to the city and people who lived and worked nearby. His defence argued King was peacefully protesting during the 3-week-long demonstration against COVID-19 public health restrictions. Well, joining me now is Kim Schofield. She is a criminal defence lawyer. Kim, what's your reaction to this ruling?
Well, I'm not surprised that there was some fault found on his part. So public mischief, which is interfering with the quiet enjoyment, and we all know that there was certainly considerable interference with the quiet enjoyment of the residents of Ottawa. But he was also importantly found not guilty of the more serious obstruction charges. So he still will, of course, face a sentencing hearing, but considerably less serious on the realm of the offences for which he has been charged.
So when we talk about sentencing, what do you expect? What sort of penalty do the counts that he's been found guilty of, what sort of penalty do they carry?
Well, mischief is a strange offense in the criminal code. So it can really be a very minor offense, and it can be a very substantial offense. So the sentencing ranges vary dramatically. For instance, a public mischief could be calling 911 falsely. It could also be sending the police on a wild goose chase somewhere. It could be interfering with a government building or interfering with the quiet enjoyment of a park. But when you hold a city hostage, which is what the Crown's going to say, hostage in a sense, that the public mischief and how much damage it's caused, as far as inconvenience and even financially, they may have some estimates on that. So it's not a simple minor offense, even though it appears sometimes that these kinds of charges are. This one, I'm sure the Crown will be taking very seriously and may still ask for a period in custody.
Okay, so you did mention, though, that the 2 counts that he's been found guilty of are the lesser charges. What do you make of the fact that he wasn't found guilty of those more serious charges? How should we interpret that?
Well, intimidation is an offense of violence. So public mischief isn't necessarily an offense of violence. So it puts it on a different realm of the seriousness of the breach of public standards. So in other words, a public mischief may be, I mean, obviously it's a criminal offense, but it may be just barely over. So a peaceful protest can potentially become a criminal act of public mischief. And that's what the judge had to grapple with here. But intimidation is never just barely stepping over the line. So intimidation is intimidation. It's a much more serious offense. And it is an offense of violence, even though it's not necessarily striking an individual. But it is a violent offense. So the public mischief, I think it takes it out of the realm of the very serious offenses. And if I were counsel on this, I would say, at some point you can cross that line from peaceful protest to public mischief, and it is not such a huge departure, but intimidation is. So I think on the sentencing front, it's mitigating, certainly, that he's not convicted of the more serious breach of public peace, I guess is the best way to put it.
All right, Kim Schofield, we have to leave it there, but we appreciate your insights today. Thanks for joining us.
Yes, thank you.
Kim Schofield is a criminal defence lawyer.